All right, so today we're talking about 7 ways that a judge can favor the prosecution during a trial. And these are important because if you know these, right, and I would watch this through to the very end, if you know that the 7th one's actually probably the most important one in some ways, right, in my opinion. But if you know these, then you can strategize, right? You can game plan with your attorney, and you can say, hey, look, if this comes up, what are we going to do, right? What are our options? How do we handle this? So, and most cases don't go to trial, but a lot of them do. If you're innocent, you're going to be very tempted to go to trial. If you watch my content, you know that I don't believe that the way that trials are set up right now, they're not fair. There's a lot of little things that are done, not just by judges, but the actual structure, the way it's set up. And it doesn't matter what race you are, what religion you are, it's unfair for everyone. So anyways, I hope this helps. And before we get started, I'd like to go ahead and point out, this is not legal advice. I'm not an attorney. Consult with your attorney. Like I said a moment ago, right? Talk to your attorney about these things here and strategize, game plan. So, and then for those of you that are new to my channel, just so you know kind of where I'm coming from, I was wrongfully convicted for 12 years. I spent 10 years grinding, reading tons of case law and trying to understand, right, the legal system and watching, right, my rights get violated every time I go to court. I watch my rights get violated before trial, after trial. Eventually, right after 11 attorneys, decided to represented myself for 3.5 years, and eventually, at that point, I worked hard and accomplished some pretty impressive things in that 3.5 years, and that's for another video. But eventually, there was an attorney that was assigned to me. He did a great job, came in, negotiated to get my conviction overturned, and so I can get my life back. So anyways, without further ado, let's go ahead and get started. So here are 7 ways that a judge could violate your rights, right? And these are 7 ways that are, some of them are pre-trial and some of them are like heading into trial and at trial. So keep that in mind. Also, this is not an exhaustive list, right? And what I mean by that is there's a lot more than 7 ways that a judge could favor the prosecution and really hurt you and hurt your rights. And if you're innocent, they could lead to your wrongful conviction, right? So pretty important stuff. So here's number 1. When charges are filed against you, right, there's this thing called the preliminary hearing, right? And some of you guys know what that is. There's a hearing where the judge has to decide whether or not there's sufficient evidence to meet the threshold requirement to take that charge and bind it over for trial, meaning you're going to trial, right? There's enough evidence that the judge feels that that this could go to trial, right? This could go to a jury, and the jury would have to choose and select, and if you're going to plead it out, it's going to be one of those things you're going to have to negotiate, right? The standard is probable cause here in Utah. In most states, it's probably pretty similar, maybe called something a little differently, and it's very vague, very it's not numerical, and it's nowhere near being specific, right? It's probable cause. It's kind of like this term that's out there. And a judge could very easily violate your rights, right, and favor the prosecution by saying, I find that there's probable cause, right? Even though the evidence might be slim, it might be speculative, right? It might just be one crazy person throwing allegations out, or it might be, it could be any number of scenarios, right? I don't have to go through all the examples, but probable cause is the standard, right? If that standard's not met, then the judge has to throw out that charge. And that's one way that a judge can favor the prosecution, is by not requiring significant evidence, right, to meet that standard. And once again, that standard is very vague, and that's tough. And that's one of the inherent kind of problems with our system, right, where there's all these different standards that are so vaguely defined that it gives like tons of discretion to a judge, to a prosecutor, to anybody in power, right, that can completely turn your life upside down. So deciding what cases or what charges meet that standard and then binding those over for trial, that's number 1. Number 2, it's during jury selection. There's this process where, right, both sides get to eliminate people, and then there's challenges where you can challenge them for cause, meaning there was something they said, right, that you think, right, was demonstrates a bias or that could hurt your client, right? Or hurt you, right? Because you're an attorney, I'm assuming you have an attorney and he's representing you. But right there during that process, I experienced it in my case where there were some people that, pretty blatantly, they were, they were biased. They definitely were not going to be, fair, right? If they got in on my jury panel. And I remember my attorney arguing with the judge, and the judge was trying to rationalize for why, oh, that's not that big a deal. Oh, everybody says that. Or, just like these trying to be dismissive over some serious concerns during that jury selection process. So that's one way there where the judge, right, could favor the prosecution in allowing a juror to stay that should not stay because for whatever reason, right, they're going to hurt you in a way that's not fair. They're going to be biased against you. And then on the other side of that as well, right, same number 2 is the prosecutor could ask to get somebody dismissed, somebody that maybe said something that implies that maybe they had a bad experience with the criminal justice system, or maybe they would favor you for whatever number of reasons. And the prosecutor can actually say, well, Your Honor, I'd like to go ahead and have this juror excused, and then they'll give their reasoning. And even if it's, baloney, right? Like, the judge has the power to decide one way or the other. So that's another way that a judge could influence in an unfair way the outcome of your trial by favoring the prosecution. So that's number 2. Number three is, so now you're getting ready to go to trial, and jury instructions have to be given, right? There's some jury instructions that are automatic, right? They're always giving those jury instructions. They're kind of like your base ones, right? There's a name for them, but they always give those jury instructions. Every state's got them, right? And then there's jury instructions that you request. So a judge has tons of discretion as far as what jury instructions are given, and that could be huge because, just as an example, right? Just because there's tons of them, but an example would be, so for example, you're charged with first-degree murder, and you're asking for jury instruction on manslaughter, right? I don't know what the facts are. We don't have time to go into all the facts, but you're asking for something on manslaughter because it's a lesser crime. Well, the judge can decide that you're not getting that. He can make that decision. So that's one example of, and that could happen with any number of crimes, right? Because typically whenever you're charged with a felony, there's a bunch of other, like minor, like sub felonies or like crimes that are not quite as severe, but that fall in that same category, right? So you can ask for some of those jury instructions, and those can be denied. So that's one way that a judge could, if he wanted to, favor the prosecution, right? He could decide, no, I don't feel that, based on whatever the standard is, right, in that state, and based on the facts of the case, he could decide that he doesn't feel that the facts of your case warrant that, giving that jury instruction. So, and that can hurt you severely, right? Because that limits the options that the jury has for what punishment they're going to, for what they're going to convict you of, and then ultimately what your punishment is. So that's number 3. Number 4, when giving jury instructions, right, outside of the basic jury instructions, right, once we get it, in fact, all of this applies to all of the jury instructions, even the basic ones. A lot of times prosecution and the defense, they start negotiating and playing around with the wording of the jury instructions. That one happened in my case where we had a jury instruction on something that we thought was worded very nice and cleanly, right, to where it was understandable for the average person. The law can be complicated, and you want to make these jury instructions as easy as possible for people to understand. And in my case, the prosecution was able to successfully convolute, right, kind of like change the wording in such a way that it made it a little more cryptic. And that can hurt you, right? Because you have 11 jurors or less, right? Or more, depending on your state, depending on the crime. And these are average people, right? Some of them might have experience with the criminal justice system, some might not. Some might have experience with the law, right? Maybe they've taken some law classes, or they're paralegals, and some don't, right? And then they've never have. You want to make those jury instructions as simple and as clean and as straightforward as possible for the average person to understand. And you got to understand, it's not just a matter of them understanding it, then it's a matter of them applying all the facts, all the complicated facts, right, that happen in a case. And some cases are a lot more complicated, and they have to apply that to these standards, right, to these rules, to these jury instructions. And then they have to also potentially persuade some of the other jury members to agree with them. So it's a pretty complicated thing. And then if you're going to just complicate jury instructions unnecessarily, then, so that's an example right there. That's number 4, where a judge, right, could potentially favor the prosecution and allow the prosecution to convolute, to overcomplicate jury instructions, right? So the wording is very important, and they can do that. So but that's up to the judge, and the judge has that kind of discretion and that kind of power where he can go, no, let's simplify that, or yes, let's keep it like that, or let's go ahead and add a couple more clauses and hithertos and whatever, right, to make it a little more difficult for the jurors. He's not going to say it in those words, but he can allow the prosecution to do that. So that's number 4. Number 5, so prior to going to trial, right, before you go to trial, they'll have these motions. They're called here in Utah, they call them motions in limine, and what that means is that you get to ask the judge, right, to keep evidence out, and the prosecution can do the same thing. And that's pretty important, right, because some of this evidence could be pivotal to your case. You're trying to get some evidence in, and you absolutely need it in, and the prosecution's trying to keep it out. And sometimes with a lot of this stuff, right, it's all discretionary. There's so much room for interpretation, and there's an example right there where the judge, if he wanted to, he could favor the state, right? There's enough case law out there, there's enough ambiguity out there that he can go ahead and find some sort of way to rationalize why the prosecution gets their way, whether it's to allow something in or to keep something out. That's an example, right? And I've read a lot of cases where that happens, where that gets litigated after somebody's convicted, right? Because they appeal it and it goes to the Court of Appeals in whatever state, and that's what the person's arguing, right? In these appellate courts, is they're saying, hey, this was unfair. This evidence should have never came in. And you'd be surprised at some of the stuff that gets allowed in, or some of the stuff that the prosecution is successfully able to keep out. Stuff that you think, well, that's basic, that's fundamental to the case. How could you not allow that in? But the prosecution will sometimes be successful in accomplishing that. That's number 5. Number 6, so now you're at trial, right? So now you're at trial, and there's a lot of objections that take place. And some of these shows that you watch on TV, they don't quite show it accurately, but generally speaking, there's a lot of objections that take place, right? Some of them are purposeful, some of them are just strategic, and both sides, right, will object usually. So anyways, my point is this though, these objections are taking place, but guess who decides? Who decides whether that objection is granted or not, right? It's the judge again. And these objections could be huge. We're talking about, they could be objections based on the fact that you don't want certain evidence to come in, right? That maybe you didn't object to before trial, but now, maybe something your attorney just discovered, right, during trial, that there's some testimony that's coming in, or or somebody is going to say something, right, that could potentially really hurt you, and it's unsupported. So he can object, right, to try to keep that out. And that's just an example. There's tons of them, and then it's up to the prosecution, right? I mean, it's up to the judge to decide whether or not to let that in. So, and it can happen the other way, on the other side of this, right? The prosecution could be objecting to keep something out, or arguing to keep something in that you want to keep out. So, anyways, my point is, the judge has tons of discretion right there, and your rights could be violated there. He could totally be biased because there are no clear-cut rules for how to decide, whether a piece of evidence comes in. And fundamentally, right, just to understand, like, I get it, like, there's a lot of discretion that needs to be involved in the criminal justice system, right? I get that. But if you held judges accountable for their decisions, right? If there's some sort of accountability, like, way of holding them, like, legitimately, right? Not something that's pie in the sky, that's written but no one ever listens to or applies or actually digs into, right? But something that you can actually, that the average person go, hey, I feel my judge was unfair, he violated my rights with that decision. If there was a mechanism in place that allowed for that, then you would have judges that would use that discretion and would be fair, right? And they wouldn't favor the prosecution. And for what it's worth, and I mentioned this before in some of my videos, I mean, I talked to so many attorneys, right? I had 11 attorneys myself, but then I had so many attorneys that I met during that process, and a number of them shared with me that, like, here, I'm sure it's the case pretty much nationwide, like, it's common knowledge among attorneys, criminal defense attorneys, that most judges favor the prosecution, right? So that's why I'm creating this video, right? Just to make that clear. And they don't like it, but they accept it. They accept it because it's just, you know what I mean? Like, there's no one, it takes time and energy to put up a fight to try to bring about some change, but it can be done. And I'm trying to do my part here by sharing this with you guys, right? So I think that if we held judges accountable for their decisions, especially when they're just blatantly wrong, right, with the decisions they make, then I think you would get judges that are more fair. Anyways, that was number 5. Let's go ahead. Oh, that was number 6. So now let's go ahead and move on to number 7. So number 7 is, if you do have a situation that no one anticipates, right? and evidence comes in that's not supposed to come in, and it hurts you, right, as a defendant, right, and you're claiming you're innocent, and somebody blurts something out, right, that's hearsay, or somebody alleges something that they're not supposed to say, there's this mechanism in place where you can not just object, but you can ask for a mistrial, meaning you get to have a brand new trial, right? The whole thing gets thrown out and you start over, which is not the best thing, but it's better than being wrongfully convicted, right? So it's definitely a nice safeguard that's there. The problem is that most judges don't grant them. They don't like granting them. Why do you think that is? It's obvious, right? It's because of the cost, right? You'd have to start all over again. You'd have to start all over again, you know, if the prosecution would have to start all over again. Even the defense doesn't like asking for those, right? Because no one wants to start the whole thing over from the beginning, right? In fact, as the defendant, right, it'd be the same thing for you. Why would you want to start the whole thing over again? It's not something, so what I'm saying is it's not something like you get some bonus or something wonderful happens if you get a mistrial. It's bad for everybody, right? Especially if you're the defendant and you're innocent and you're incarcerated because you can't make bail because your bail's too high, then that means you get to go back to your little cage, your little concrete cage, and you get to hang out for the next few months or whatever it is, maybe longer, maybe less, until you have your next trial. But it's still better than being wrongfully convicted, especially if you're being charged with something pretty serious. That could be a life sentence, right? These are 7 ways, I hope this was helpful. These are 7 ways that, you know what I mean, that a judge can violate your rights by favoring the prosecution. At least you know about them now, right? If you ever find yourself in a situation or you know somebody, you can meet with your attorney, talk to them about these, and see if you can find a way to mitigate, right? To strategize, to try to prevent them from happening or coming up with some good options, right, for what you can do. Anyways, I hope this was helpful, and I'll see you in my next video.